Honorable members, our Deputy Minister for Culture and Traditional Affairs, our officials, the Secretariat of the committee, you are all welcome to this meeting. It's now exactly 10 o'clock. We are beginning with our business of today. I've been looking at the attendance. We do correct. We have all members of the select committee that are supposed to be here with the apologies we have received. And we do have the provincial portfolio chairpersons from different provinces of our country. We also have members of portfolio committees who have joined from Limpopo and Gauteng.
Chair, I'm sorry for interrupting you, but there's an echo on your microphone, so it's very difficult. You're not audible.
Thank you very much, Honorable Badenhorst. I'll request that all members mute their mics and their videos. Honorable Wilson, if you can also mute your video.
Sorry, Chair, didn't realize it was on.
Yes, I see Honorable Skirkocher, your video is on. I see Honorable Jacob, your video is on. Honorable Senweli, if you can mute our videos and microphones, we'll only unmute when the chair recognizes you to speak, and the rules dictates that when you speak, you must open your video and you must also you unmute your mic. How is the reception now, honorable members? Am I audible?
Oh, that's better. Thanks, Chief.
Thank you very much, members. Let's begin with our business of today. We'll just move straight to apologies so that we'll get an indication for those who are unable to attend, and before we make remarks, to ascertain that the meeting does correct. Mr. Manele, over to you, sir.
Good morning, honorable members and everybody in the meeting. My name is Mos Manele. I am the secretary to the committee. Chair, just for record, one, we have an official apology from the minister. From the committee is officially, the apology tabled is from Honorable Zimande, who is briefing the Gauteng legislature on the objects of the Public Service Administration Bill. Thank you very much, Chairperson.
Thank you very much, Mr. Manele. I didn't see you on the video here. I don't know what happened to your video, but it's fine. The rules dictate that we must all show our faces so that we are not going to be talking to the ghost. With that being said, let's then move to the next item on the agenda.
Sorry, Chairperson, hello. My hand is just raised for apologies.
Okay. Yes, Honorable Priyat.
Thank you. Listen, I just have two apologies. The first apologies is from the chairperson of the COCTA Portfolio Committee of the Free State Legislature. Honorable Klute cannot make it to this meeting today as he has he needs to attend to, and Honorable Theo Ubar, chairperson of the Northern Cape Portfolio Committee on COCTA, will also not be present in today's meeting. He did not receive notice of this meeting, and he has prior engagements that he also needs to take care of. So just those two apologies to note. Thank you so much.
Thank you, Honorable Priyat. With the notices, I'm sure there's a challenge maybe to communicate in their own space. I think the message was issued to all provinces on time. And even the schedule of meetings for this committee, which we adopted, was also issued to all chairpersons or legislators, provincial legislatures. So we are certain that the message indeed would have been conveyed in that manner. Without any further ado, if there are no further comments, and in the near future, I'll request that the chairpersons forward their apologies through the secretariat so that we can record properly and announce those apologies when we start the meeting, as Mr. Manele was doing. Without any further ado, let's then continue to the welcoming remarks to all members and participants to our meeting. I'm hoping that I'm still audible, members. Am I still with you?
Yes, sir.
Thank you very much.
Yes, sir.
Firstly, I would like to welcome our Deputy Minister, Honorable Prince Zolile Benz Ngamash, who's the Deputy Minister responsible for traditional leadership in the department and Khoisan affairs. We also recognize the senior officials delegated by the Director General to present before this committee. We received an apology from the Minister, Honorable Velenkosi Nihlabisa, who's also engaged on other departmental businesses. We accepted his apology as he decided to delegate the Deputy Minister to come and represent the ministry. We also wish to acknowledge that the President presented a very progressive State of the Nation address, which have touched on a number of issues and challenges that are facing this country and the vision. Where do we want to go as a country in terms of economic growth, and how do we respond to issues of both macro and microeconomic aspect so that we can create new jobs and also ensure that there's inclusive growth in our economy. But he also highlighted a very important role by the municipalities to become the strategic corridors of economies in the country. And how do we ensure the linkages between the cities of our country to ascertain that we do respond to the aspirations of South Africans, especially the communities living in rural areas and in township where there have been lesser opportunities exposed to themselves. The President also re-emphasized the point he has made in the previous State of the Nation address on how can we expedite the issues of reviewing the white paper on local government, which entails the funding for municipalities in our own country. So, which is very important and key to the work that we are doing of oversight. Therefore, we'll be continuing to conduct oversight over that matter. We also meet today to get a presentation on the Independent Municipal Demarcation Authority Bill and the provincial statistics of the customer initiation debts and how are we faring in terms of implementing the Act in relation to this aspect. We also recognize that looking at the decision that this committee took to actually afford provinces with another space to go and consult on this bill was more than welcome by all provinces so that we'll be able to allocate adequate time for all provinces to consult in processing this bill through public hearings that needs to be conducted. Hence, the public briefings, the portfolio briefings are already beginning to take place in most provinces. The other indication that we want to give to the committee is that cooperative governance and public administration will also, during this second term as a select committee, engage the Department of Cooperative, Governance and Traditional Affairs on the review on the funding model and white paper on local government. So we'll take this as one of our priority programs. Committing also that as the Select Committee on Cooperative Governance and Public Administration, we will also ensure the finalization of the Independent Municipal Demarcation Authority during the 2025 parliamentary second term. There is no way we can postpone this. This bill has been with us for quite some time. As part of ensuring public participation in legislative processes, we commit further that the Select Committee on Cooperative Governance and Public Administration will on the 31st of March places adverts in national and regional newspapers requiring members of the public to start submitting their written submissions on the objects of the Independent Municipal Demarcation Authority Bill. That will be unlocking the process for public hearings. We must also indicate, honorable members, that the Select Committee will also has taken a decision to restart the process of considering the Independent Municipal Demarcation Authority Bill through provincial legislatures, which should be given 8 weeks cycles to conduct their own public consultations processes, tabling of negotiating and final mandates in this NCOP in this second term of 2025. This is our commitment that we are making to all of us as members as well as the provinces. We wish also to inform the committee that Eastern Cape Provincial Legislature has scheduled a meeting on the 28th of February 2025 and requested the permanent delegates accompanied by officials to brief them on this bill so that they can start the processes of engaging the public. Sorry?
Apologies for the interruption, but that echo.
Is it coming back?
Very clear on our side.
Yeah,
Yeah,
we can hear you. We can hear you, Chair.
Yes, Chair.
Yeah, I'll further request all members to mute their mics, as I've requested before, and your videos. Please, let's mute our videos and our mics. Thank you very much. So we're saying that we need to finalize this process as scheduled in our program. The Select Committee also has been given a mandate by the Office of the House Chairperson of Committees in the NCOP to conduct post-legislative impact assessment on the customary initiation bill and table the report before the 24th of March 2025. We are indeed going to engage in that activity and ascertain that we develop such a report on the impact of the bill. Then the other item that will be seized with as the Portfolio Committee is that in line with the provision of Customer Initiative Act of 2021, the Select Committee will also be engaging role players such as national and provincial departments of cooperative governance and traditional affairs, the National House of Traditional and Khoisan leaders, provincial premiers, the national and provincial initiation oversight committees and MSCs responsible on action plans to deal with challenges related to kidnapping, mushrooming of bogus traditional surgeons, illegal initiation schools, death and non-compliance with the legislation framework. So we'll be engaging in that exercise. Honorable members, we wish to further indicate that the Select Committee will be engaging during the 2025 parliamentary second term, the Department of Cooperatives and Traditional Affairs on the state of local government report and support provided in terms of Section 154 of the Constitution to dysfunctional municipalities across the provinces. The reason why we'll be engaged on this is because it necessitates that the work on oversight by our committee should be looking at how municipalities are functioning, as well as identifying those municipalities with challenges that are faced with, which are referred to as dysfunctional municipalities. We'll be conducting this through engagements as well as oversight visits that we'll be conducting, as we'll be starting with Free State next month. We'll be staging a visit to Free State province and the Western Cape and other provinces. So we are looking at these members because local government is such a cold face of service delivery. Local government is located strategically to deal with issues of economy at their own local spaces. So therefore, it's important that we should be having functional municipalities, viable municipalities, municipalities which handles their finances as expected, and municipalities with capacity to deliver. Because the capacity to deliver, if it is not deliberately built by municipalities, we are not going to be seeing any change in terms of transformative local government. So therefore, it necessitates that all these aspects, as well as looking at the unfunded mandates that the municipalities are also carrying through, which in some of them, they get partial funding from both provincial and national departments, but they find themselves having to feed the bill in terms of the rest of expenditure in those unfunded mandates, which really they can't also live without, because if they can neglect or just do away with such mandates, they will be challenging the service delivery aspect of their municipalities. So we are going to be looking at all that and how we are faring in terms of Auditor General's report and what are the interventions and remedial interventions that are put in place to mitigate that space and support municipalities in terms of Section 154 of the Constitution. And we'll be looking at the impact as well of how the implementation of Section 139 have impacted on issues of service delivery, and how are we faring in terms of assisting those municipalities that interventions are already put in place, and the extent in which such interventions are really changing the tide around so that we can be able to have functional municipalities. So with those few remarks, members, you are all welcome. We are now going to be moving to the next item on the adoption of the agenda. Can I get an indication from members? I'm looking at my screen. I haven't seen any hand. Can we get a mover? Honorable Muimang, Honorable Chief Whip.
Good morning, Chair and the department and the team that support the committee. I rise to move that we accept the agenda.
Thank you very much, Honorable Chief Whip Muimang. Any seconder? Honorable Molokome, our whip of the committee.
Thank you, Chair, and morning to members on the platform. I second the move that we adopt the agenda ATC. Thanks.
Thank you very much, Honorable Molokome. And the agenda is now duly adopted since we have the proposed and the seconder. We take the first item on the agenda, and it gives me pleasure to welcome our Deputy Minister Ngamashi to take us through the presentation and also allocate the officials that will be assisting in the presentation. Thank you very much. Over to you, DM. Is DM present?
Honorable Chair,
Yes.
this is Kevin Naidu from the Department of Cooperative Governance. I do not see Honorable Deputy Minister Mamata on the platform. I do see DG Dipofa.
Okay. If we do have a challenge, we will continue the meeting, but we'd like to emphasize that as we agreed in previous meetings, that delegations should be led by politicians because we are politicians at this level. So therefore, delegation should be led politically, and the delegations will be done through the DGs in terms of your good selves as officials to take us through. But with the absence for now of the Deputy Minister, let me hand over to you, Mr. Naidu, to continue.
Thank you very much, Honorable Chair. I am Kevin Naidu. I am the Deputy Director General responsible for policy, governance, and administration in the Department of Cooperative Governance. Good morning to yourself. Good morning to all honorable members of the committee on the call. Good morning to my colleagues, DG Dipofa from the Department of Traditional Affairs. I do see the CEO of the Municipal Demarcation Board on the call as well. So good morning, and to all colleagues, officials from the departments and the Demarcation Board. Honorable Chair, the presentation that we are about to make to the committee has been made previously, and I think the last time that we were here was on the 14th of October last year. The presentation is structured thus. I will be co-presenting, Honorable Chair, the provisions that reside in the Independent Municipal Demarcation Authority Bill. And then, as members of the committee would recall, the bill had undergone a previous NCOP process, which resulted in provincial legislatures being engaged. And if the chair would allow, we would like to perhaps also give a sense of what the comments were coming in from that process and responses to the negotiating mandates received at the time. So just in terms of background, the bill that we have before us has been informed to a large extent by inputs that we have received from previous boards, but also from the present Municipal Demarcation Board. It's informed by lessons that we have learned from previous municipal boundaries and ward limitation processes, from litigation, as well as inputs from various stakeholders. The bill was published on the 17th of June 2020 for public comments. It was informed at that stage by a series of engagements, but also a workshop that was undertaken that included several stakeholders at that time. Post the publication in the Gazette, we had also subjected those comments to a stakeholder workshop, and the comments that were received from that stakeholder consultation process. Due to the many amendments that had resulted from that consultation process, it necessitated that the entire Act 27 of 1998 be repealed and replaced with a new piece of legislation, We note also that that Act of 27, 1998 was the first piece of legislation that emanated from the 1998 White Paper on Local Governments. This slide basically indicates the roadmap, the timelines since the approval that we had received from Cabinet to introduce into Parliament, which was in March 2022. The bill then being introduced into Parliament at that time, a notice published in terms of the rules of Parliament, public hearings that were undertaken by the COCTA Portfolio Committee through from July to September of 2023. The Portfolio Committee then considering a report emanating from those public engagements, then the bill being referred to the Select Committee, and then the department providing a briefing to the Select Committee in February of last year. The bill was then, as I've indicated earlier, referred to provincial legislatures as is required in terms of the legislation. The bill was subjected to public hearings and then the submission of negotiating mandates by the provincial legislatures to the National Council of Provinces. We had, and we will show later on in the slides, Honorable Chair, the various engagements that we had undertaken with the provincial legislatures, basically providing clarity, technical clarity in relation to what are in the various provisions in the bill. Like I've indicated, the last time that we were here was on the 14th of October, where we had briefed the committee on the negotiating mandates received at that time. The structure of the bill is as follows. So we basically have 5 chapters that make up the demarcation bill. Chapter 1 deals with the definitions, purpose, but then the real core provisions reside in sections 2, 3, in chapters 2, 3, and 4 of the bill, dealing with exactly what the authority is meant to deal with, what municipal demarcation, what municipal boundary demarcation, redetermination, as well as the demarcation appeals authority is provided for in chapter 3. Chapter 4 deals with capacity assessments, and then miscellaneous matters are dealt with in chapter 5. The following slides, Honorable Chair, deals with the provisions that are in the bill, clause by clause. So we have provided at a very high level what resides in each of the 50-odd provisions that are in the bill. Perhaps to start with, and the naming of the bill, you would know that the present legislation is referred to as the Local Government Municipal Demarcation Act. We have, having due regard to the provisions in the Constitution, aligned as far as possible as we could the naming of the legislation with the provisions in the Constitution. So you would see that it aligns to section 1553B of the Constitution, which provides that national legislation must establish criteria and procedures for the determination of municipal boundaries by an independent authority. So those 3 words finding direct expression in the naming of the legislation. The long title has now been adapted to provide for capacity assessments of municipalities, but also for an appeals authority. Due to the inclusion of these new provisions, it was necessary to provide definitions for the new terminology in the bill. In relation to clause 3 in the bill, we have now indicated that the authority is made up on the one hand of the board, and then on the other hand, the administration, whereas in the previous naming of the legislation, Municipal Demarcation Board, did not provide for that kind of delineation. In relation to the functions of the authority, we now, in addition to what is in the present legislation, indicate clearly that the function of the board is to also conduct municipal capacity assessments. You would know that this is provided for largely in the Municipal Structures Act, and we thought that it would be opportune now to provide for this function in the demarcation bill that we have before us. Clause 7 deals with the composition of the board, and you would see, Chair, that in certain instances for clarity or for amplification, we've highlighted certain provisions or highlighted them in yellow, and then highlighted some or shaded some of the provisions in green. So in clause 7, for example, reflect regional diversity has been amplified by now making changes to broadly reflect the composition of South African society. The PC that you see shaded in green was a proposal that had come out of engagements, discussions that we had in the portfolio committee. You will see further on in the presentation towards the end of it, where we make this clear kind of clarification from the input that was received from the Limpopo Provincial Legislature. In relation to the qualifications of board members, we have now added a requirement for a qualification in information technology. And this is given due to the fact of the work being generally very technical at the board. We've now also indicated that full-time employees of an organ of state cannot be board members. We've provided for in the selection panel when it comes to the appointment of board members that the portfolio committee in the National Assembly and a member of the National House of Traditional and Khoisan leaders also be a member of the selection panel. Clause 11 deals with the term of office and it being 5 years. You would know presently, Chair and honorable members, that when the board is presently appointed in terms of the existing provisions, you would get 2 boards overseeing the one board overseeing the ward outer boundary determination and another board coming in and dealing with ward delimitation. The way we have now provided for the term of the board is that that single board would be responsible for overseeing or determining or finalizing outer boundaries of municipalities, but then also dealing with the inner ward delimitation of municipalities. So it would end 6 months after the commencement of a term of local government, and as soon as that happens, you would get a new board coming into office. A member of the board may not hold office for more than 2 consecutive terms and would cease to be a member if he or she is absent from 3 or 4 board meetings. The next clause that we wanted to amplify would be clause 16, and this deals with committees, and that which is highlighted in yellow, where you see that the names of board members of committees must be published on the website of the authority to ensure transparency, and it is a proposal that had come from the portfolio committee on COPTA after discussions and engagements at that committee. In relation to clause 17, which deals with the delegation of an instruction to exercise powers and perform functions by the board, it provides that the board may delegate any of its powers to a member, an employee, or a committee of the board, excluding the power to make the final decision on the determination of a municipal boundary. Clause 19 provides for the chief executive officer. The present legislation provides for the head of the administration, refers to him or her as the manager. We've changed that to now him or her being the chief executive officer. The conditions of employment of employees derives now from the Public Administration Management Act, and we say that officials may be seconded to the authority from other organs of state. Clause 23 deals with the determination and the redetermination of boundaries, and it references the objects of local government as provided for in Section 152 of the Constitution, but it also additionally now provides that determination of boundaries must be aligned to SCLUMA. Clause 24 deals with the factors to be taken into account, and importantly, an addition that we have now included is that the views of the people and communities living in the area must be a consideration. And in fact, it is a proposal that had come directly from the Office of the Chief State Law Advisor when we were engaging them in relation to obtaining certification for the board. Clause 25 deals with the categories of municipalities, and what has been done here is that we've migrated sections 2 to 4 of the Municipal Structures Act into this bill. Clause 26 provides for the initiation of determination or redetermination of municipal boundaries, and it provides that outer boundaries or major redeterminations will only take place after every 10 years. And when you look at the definition of major boundary determination in the bill, you would see that if the redetermination affects more than one ward, that would take place once, but 10 years after that, once again. The board will not determine or redetermine municipal boundaries after the minister publishes the formulae for determining the number of councillors. So just in terms of sequencing, when outer boundaries are redetermined or determined by the authority, it is the responsibility then of the minister to publish a formula to determine the number of councillors. And once that is done, there can be no changes to outer boundaries thereafter. Clause 27 provides for the notice of intention to consider a request for determination or redetermination. And in this instance, it would require the authority to publish a notice in the area concerned, stating its intention to consider a request for the determination of a municipal boundary. The notice will invite written representations and views from the public within 30 days, but it also targets comments to be provided by the minister, MECs responsible for local government, SALGA, the affected municipalities, the magistrate in the area, as well as from traditional Khoisan leadership structures. The board will then be required to institute a formal investigation, unless if it is a minor technical adjustment, after receiving views and representations from stakeholders. The authority will then publish a notice in a local newspaper informing stakeholders of a public meeting to look at the submissions received. Mechanisms, processes, and procedures for public participation are then provided for in Clause 30 of the bill. Clause 31 provides for the publication of an objection to the determination or redetermination of a municipal boundary, which would require the authority to publish its final determinations in the Provincial Gazette for comments. In Clause 32, after finalizing a boundary determination, the authority must send particulars of determination to the IEC and to the relevant MEC for their review. So pretty much a similar scenario prevailed as it does presently. Clauses 33 onwards deals with the delimitation of ward processes, and it requires, at the instance that the minister publishes the formulae for the number of councillors, with the authority to publish a delimitation of wards timetable in the Government Gazette. So pretty much what the IEC does presently, when it plans for the holding of elections, it publishes an electoral timetable in the Gazette. The authority would now be required in the future to do a similar kind of timetable for public consumption. The number of wards must be equal to the 50% of the number of councillors in the municipality, so determined by the MEC for local government in the province. The number of registered voters in each ward may not vary by more than 15% of the norm, which is pretty much what prevails presently. We have also provided that the authority may deviate by not more than 30% of the norm, but only in exceptional cases. So exceptional cases you would see in the bill is instances where communities are split, or where there are geographical obstacles, if I can state it like that, which would require a deviation of not more than 30%, so that communities are, as far as possible, kept in the same ward. But of course, this would be done in exceptional circumstances. And when it is done, it would require the authority to once again publish such intention in the Gazette for comments. In relation to public participation in delimitation of wards, a similar process as provided for in the determination of outer boundaries must now be followed for ward delimitation. So presently, you would find that the board would publish its determinations, ward determinations or delimitations in the Government Gazette for 14 days and for comments. And if none is received, it will then thereafter confirm such wards. Of course, that is provided for in the legislation, but may not necessarily be the modus operandi when the board presently does its ward delimitation. Clauses 38 to 46 in the bill provides for the demarcation appeals authority. This has been something that has been welcomed by various engagements that we've had, mostly because the current Act does not provide for an appeal mechanism or dispute resolution process against the decisions of the board, except for aggrieved persons to approach the courts to review the decisions of the board. So by this intervention of providing for a demarcation appeal authority, which will now allow stakeholders to make representations to an independent authority without necessarily expending resources by going to the courts. This slide basically summarizes the slides that I've just gone through here in terms of what lives in sections 23 to 46 of the bill. And that is the criteria for determination, the determination itself of outer boundaries of municipalities, issues relating to public participation, matters relating to delimitation, and of course, lastly, as I've just indicated, the establishment of the Demarcation Appeals Authority. Chapter 4 of the bill provides for municipal capacity assessments, as I've indicated at the outset. You would note that presently the present provisions in the Demarcation Act of 27 of 1998 provides for the board to undertake capacity assessments of local and district municipalities. It is silent on doing so for metropolitan municipalities. So we now say that the authority must conduct municipal capacity assessments to support its decisions, but must also provide assistance and guidance to the minister and the MEC regarding the assignment of functions and powers, also rendering an advisory service. Importantly, we say that the authority must conduct at least one municipal capacity assessment in respect of each municipality during the term of the municipal council. So with the 5 years that we have, term that we have for municipalities, at least one capacity assessment must be had. But resources permitting, it can conduct a midterm assessment after 24 months and conclude it within 6 months after the commencement of the term of the municipal council. So when you look at the sequencing of the municipal capacity assessments, we say that it must be completed at least 6 months before the end of the term of the municipal council, so that when you have a new or incoming demarcation authority, that capacity assessment which have been concluded at that time would be handed over to the incoming board or authority to look at, to inform the outer boundary assessments and determinations that the board would undertake at that point in time. Clause 48 deals with regulations and guidelines, and we provided now that the minister must submit draft regulations to Parliament for parliamentary scrutiny at least 30 days before their promulgation. It was something that was discussed and proposed in the discussions with the Portfolio Committee. Offences and penalties, we now provided that there should be penalties for offences, because the present legislation does not provide that the board with the option of the sanction, which results in some instances in delays or failure to execute its functions. We repealed through Section 55 the sections 2, 3, and 4 of the Structures Act, as well as items 2 to 5 of Schedule 1 of that same act. So for items 2 to 5 deal with delimitation criteria, and sections 2, 3, and 4 deals with categorization of municipalities. The entire Act 27 of 1998 would be repealed through this piece of legislation. In relation to transitional arrangements, we indicate that any determination matter which was investigated by the board before the Act took place is regarded as having been concluded in terms of the existing legislation, and it provides for ongoing ending of operations of the existing board. The Act will be called the Independent Municipal Demarcation Authority Act, and as I've indicated, the rationale behind this is for alignment with the provisions that are in the Constitution, more especially Section 155 thereof. In summary, Honourable Chair, we have highlighted through this slide some of the key features in the bill before us. We've dealt with the alignment and the naming of the bill in relation to alignment with the Constitution, that the authority provides for the board on the one hand and then the administration. The term of the board being aligned with the term of municipal councils. Importantly, and you would have picked up that the common thread throughout the provisions in the bill is consultation, consultation, and consultation. And we value the views of the people and communities living in the area when it comes to outer boundary demarcation, but also inner boundary delimitation. Major redeterminations to take place after every 10 years were required, and this is to ensure stability. No redeterminations to be made after the formula for the number of councillors has been finalized and published in the Gazette by the Minister. The public consultation and reports from investigating committees is shared prior to community engagements, and that the authority may also engage with other interested parties. May not deviate by more than 30% with exceptional circumstances, and we've indicated that that is mostly to ensure that we do not split communities. Public participation in the delimitation of wards is enhanced, provided for the establishment of the Demarcation Appeals Authority, and the reasons thereof were provided through in the presentation, and that we've also provided for in a separate chapter in the legislation for municipal capacity assessments. Honorable Chair, that would be the presentation on the provisions in the bill. I have, while going through the bill, or the provisions clause by clause, indicated the proposals that were made by the COCTA Portfolio Committee pursuant to the engagements that they had had, and then presenting their report to the department and the ministry. Perhaps what I may not have gone through is the proposals in relation to clause 32, where they have indicated that it should be 9 months prior to the commencement of the municipal financial year, where the board informs the minister and the Minister of Finance of any such determination or redetermination. The next slide, Honorable Chair, deals with the briefings that we have provided to provincial legislatures, and you would see that at around this time last year, we had, as the department, supported the various provincial legislatures, 8 of them, except the Eastern Cape Provincial Legislature. There was no invitation that was extended to ourselves. But from the 9th of February last year to the 22nd, this exercise of briefing supporting was provided to the relevant provincial legislatures. The next slide, Honorable Chair, deals with the negotiating mandates that we've received from the various provinces. At this stage, I would like to hand over to my colleague, Mr. Shlomulo Mata, to take us through these submissions that we've received from the 8 provincial legislatures. Honorable Chair. With your permission, Chair, I'd like to hand over to Mr. Martin. Thank you very much.
Thank you. Granted. Mr. Mata, you can proceed.
Thank you very much, DDG, and good morning to the chairperson and the members of the select committee, as well as other members that are represented in this specific sitting. I'll be taking through, as directed by the DDG, carrying over in terms of the negotiating mandates that have been received by the MCOP in relation to this specific bill. The first negotiating mandate that we have received came from the Northern Cape, and part of those were much more of a general, which they felt that the communities now are excluded, and why Namakwa region was excluded from such processes, and why is it not recognized in terms of Chapter 12 of the Constitution. And we are saying that part of the intention of this specific bill was to try and maximize public participation through the ward delimitation process, as well as the municipal boundary determination process, which the DDG has dealt much more in greater detail in his presentation. So the other negotiating mandate that we have received came from the Northwest, dealt with clause 26, dealing with initiation of determination or redetermination of municipal boundaries. And the feeling was that this clause is silent regarding the criteria used for determination and redetermination of municipal boundaries. And they felt that while, be that as it may, we might need to also insert this in this specific provision, that the board, while carrying its function of determination and redetermination of municipal boundaries, must also consider access by communities to service delivery institutions and the existing wards and the impact thereof. And this is not supported for the reason that the bill itself provides for comprehensive list of factors to be taken into consideration when determination of municipal boundaries takes place. And that is detailed in greater details in section 24 of the bill, which includes service delivery boundary, functional boundaries, such as health, transport, police, and other related service delivery boundaries. And next slide. And the other negotiating mandates came from the KZN. It was specifically on the appointment of the board members and the committees that may be appointed. There was a feeling that perhaps the names, over and above the names that the board members are appointed, we need to also include their qualifications in the gazette that the president proclaims after the appointment of the board members, which is supported and it has been effected as part of the proposal that it must also include their qualifications, including the members of the committees. Their qualifications also need to be encapsulated. So the other proposal relates to the appointment of the board as well. And there was a feeling that the manner in which the vacancies of the board as provided for in clause 10.8 must be reviewed, and also it should be also subjected to a time frame because as it stands now, it's open-ended and may exclude other persons that may be eligible. So the view was that the term of the board, as it's 5 years, it should be there should be an option to renew for a further 10 years in total, which may result in the list becoming outdated at points. So they propose that perhaps we need to include the time frame within which the vacancy arose in terms of filling of those vacancies. So this is not supported for the reason that the bill already makes the provision for the minister to initiate the relevant appointment process if none of the candidates are not available from the list. And this was to try to avoid the intense process that is associated with the filling of vacancies for appointment of the board members. And the other proposal relates to clause 38 dealing with establishment and the constitution of appeals authority. The feeling there is that there may be a need for a more comprehensive process in clause 38 for the appointment of this demarcation appeals authority to be similar to the process in clause 10 that relates to the appointment of board members, considering that the appeals authority decisions of the board will lie to this higher juristic body. And this was not supported on the basis that there should be a clear delineation in terms of the identity of the board versus the demarcation appeals authority. So the other negotiating mandates came from Gauteng, and it related to the responsibilities of the board. So the proposal was that perhaps there should be an addition that would provide for the board to act independently at all times with unfettered discretion, and to exercise independent judgment and take decisions according to the best interest of the institution. This was not supported chairperson for the reason that the status of the board as provided for in the act, in the bill now, is not necessarily questionable, given that the authority still it provides for the authority to perform its function and perform their responsibilities without fear, favor, or prejudice. And the other proposal came from in clause 16.3, dealing with the committees that the board may appoint. So they were saying that the criteria and qualifications for the co-opted members are not specified, and therefore the province proposes that the co-opted members should fulfill the requirements set out in section 9.1, which that relates to the qualifications of the board members. So this is supported, and that has also, the proposal is made that the same as set out in 9 should apply. Also in the same specific provision, they felt that there should be a limitation in terms of the number of members that may be co-opted, and this is not supported, as the bill itself now empowers the board to determine its procedures in terms of its operations. So we're saying that that can be dealt with within their rules of procedure as contemplated in section 15 of the bill. So the other aspect relates to initiation in clause 26 of the determination or redetermination of municipal boundaries. And there was a feeling that a key consideration must also be given to the term of the office of the board, which is 5 years, and the time frame for determining and considering the redetermination of municipal boundaries within 10 years. There was a feeling that this may cause administrative challenges, as the two boards will consider redeterminations, and it's something that has been noted. And as the DDG has indicated, the term now was mainly to ensure alignment with the term of office of the board, which is already addressed. In clause 40 deals with the qualification of board members of appeals authority, and there was a feeling that the appointment of the board is too restrictive because ordinary citizens are not given a chance to be part of the board. And on the appointment of the board, there is need to provide for clarification of the convener of the board as the judge. So this is supported, but however, the bill does offers an equal opportunity for the appointment of chairperson and other members of the appeals authority to collectively represent a broad cross-section of the population of the Republic. And also, however, given the nature of the work to be conducted by the appeals authority, such persons must at least have a proven experience in demarcation issues and sufficient legal background and experience in relation to the redetermination. So in section 40 of the Act, there was also a comment there, and which they felt the province recommended that perhaps the 3-year budget that are provided by Treasury for measures, it need to be accommodated to deal with transitional costs, such as the human resource and technical for the redetermined municipalities, which is noted because as it stands now, such money are being provided from the national fiscus to cater for the transitional cost associated with the redetermination. And there's also a proposal for National Treasury to continue to monitor where the support is needed beyond the 3-year period, and the funding not just be limited to the integration of administrative system. And I can say, Chair, that based on that national fiscus, where there's a need, there is such support post the amalgamation. And also, when merging municipalities, the board does not take into account the financial viability of the municipalities. So part of the factors that need to be taken into considerations as part of the determination process also include the board having to take into account the financial viability and the capacity of such a municipality to perform its function effectively and efficiently. And that has already been provided for in clause 24 of the bill. And the other proposal came to clause 26, and the feeling is that in line with the municipal boundary determination, the province proposed that the ward delimitation should be done after 10 years, which is not supported for the reason that within the municipality or a ward, within that 5-year period or 10-year period, there would have been a lot of sort of a migration and changes within ward or municipalities. And so it becomes necessary that the board timelessly within the 5-year term at least redetermine those wards and reconfigure those. So as the other comment came to in relation to the municipal capacity assessment, and while the province welcomes the inclusion of the capacity assessment, but there's a feeling that the bill does not go far in ensuring that capacity assessment are well defined. And to this end, the province proposes that the Municipal Demarcation Board and the Department of Cooperative and provinces must develop a guideline for conducting capacity assessment. And this has been noted, but the bill itself does provide for the minister to prescribe for any regulations incidental to the Act, which may also deal with the indicators and criteria and other factors that may be taken into consideration by the board when conducting capacity assessment, which can be detailed in the regulations. So the other matters were sort of a general in nature and also include that they felt that a provincial representation or provincial offices opposed to centralized national office as it is now, it should be also be considered to make it easier for municipalities and communities as well as stakeholders to engage and interact with the authority, and which Chair has already been catered for in the bill. And clause 6 of the bill provide or empowers the board to establish its own staff establishment, and including appointing employees in those and the filling of the vacancies there too. However, having due regard to availability of funds to acquire any right in and to property and the ownership in immovable property, which may be acquired, but only within the consent of the minister. And the other general matter relate to how will the bill affect the traditional royal house, and this has been catered for. The bill also makes a provision for traditional leadership and cohesion leaders at all levels from local, provincial, and national house to be party to the process of redetermination of ward and municipal boundaries. And also the bill again also provide for areas of traditional leadership to be part of those amongst of those factors to be considered when a municipal boundary or ward boundary is determined. And the other negotiating mandates came from Mpumalanga, and it related to the functions of the authority and the composition thereof. And the feeling there was that the Mpumalanga House of Traditional and Cohesion Leaders indicated that those clauses that are depicted on the left side, perhaps the composition of people who must serve in the authority should be people who understand the nature of demographics in the areas in which they reside, especially in the rural areas. which has already been catered for, as the bill also makes a sufficient provision for consultation of the traditional and quiescent leaders at all levels, from local, provincial, and national houses. And as I've indicated, areas of traditional rural communities are part or amongst those considerations that the board must take into account when determining municipal or ward boundaries. So in clause 38, relating to establishment and the constitution of appeals authority, there was a feeling that perhaps there should be a determination of time for the handling of each appeal case, and a member of who lodged an appeal should continuously be updated on any developments of their case or appeal, and all the cases or appeals should be dealt with within a space. This is noted, however, Section 43 in the bill provide a detailed process in terms of appeals handling, including the relevant timeframes are provided therein. And there was also proposals around the appointment of board members, which the province felt that the process outlined for the appointment of board in clause 10 does not leave much room for appointment of independent members of the board. And for the selection panel, say for the appointment of the constitutional court judge designated by the Chief Justice, and the appointment of the chairperson of the Commission for Gender Equality, that all the appointments are laced with a political connection. And this is noted, but however, we do indicate that the composition of the selection panel, it goes far beyond the representation of only the MPs. And it also has other panelists that are provided for in clause 10 as it relates to the selection panel. And also on the appointment, what they do indicate is that the process itself is initiated by the minister, who must at the end send the names to the president, which must consist of 3 names more than the required number. The community had a concern that to ensure that we have a more open and accountable process, perhaps this process for selection of board members should be left to Parliament, should be given to Parliament to conduct the selection process for the appointment of board members, and not a selection panel. And this is noted, but the composition goes far beyond the representation of only MPs. It has the MPs, but over and above that, there are also other chairpersons of other institutions that may be represented. So 22 deals with finances of the authority, and what the province indicates is that by stating how the board will address the unique challenge of lack of resources, which often hampers the board from conducting its work effectively. And this has been already catered for, as the bill as it stands now provide for the board to be funded through the money appropriated annually by Parliament to enable it to exercise its powers and functions effectively and efficiently. And it also provides for the authority to receive money from any other source through the National Revenue Fund, of course, subject to the conditions of the National Revenue Fund. And the other matter is just general, that the demarcation should do a thorough verification through consultation with the House of Traditional Leaders and the entire community, which is already catered for, as the bill makes an ample provision for consultation of the traditional and quiescent leaders at all levels, and the areas as well of rural traditional communities are also party to. And the other proposal negotiating mandate that we've received came from the Free State related to clause 10, which the bill, there's a feeling that the bill must also designate a percentage of the board to the people living with disability. This is noted, but is a matter that a selection panel may consider this as part of its decision-making procedure. And suffice to say that the chairperson of the gender equality or his designee is also part of the selection panel. And in clause 10 deals with the appointment of board members, and it says the bill must direct that advertisement for the nomination must be made such that they also reach people who don't have access to mainstream media. And this has already been catered for. The bill makes provision for accessible media platform for publication of the advertisements, which are already catered for through various means of communication. Clause 10's appointment of board members as well. There's feeling that the individuals to be appointed must be subjected to a screening and vetting process to avoid people who misrepresent qualifications. This has been supported, and it also had been considered that before those people that must be appointed must also be subjected, their qualifications must also be subjected through vetting and screening process during the recruitment process prior to recommendation to the president. Clause 24 deals with factors to be taken into considerations, and the feeling there is that the determination of powers must take into account the geographic, economic, and social factors, amongst others. And this has already been incorporated in clause 24 of the bill. And 38 deals with the establishment and the constitution of appeals authority. And there was a feeling that the appeals authority must be made accessible, and their contacts thereof must also be provided, which is a matter that may be for consideration in the regulations. And clause 33 around the delimitation of what, there was a feeling that the 10-year period for what delimitation, they are proposing that perhaps the what delimitation must be done or conducted within the 10-year cycle, which is not supported given the reason that I provided in the preceding slides, that there could be a migration within a ward and the population changes within a 5-year period, within the 10-year period. So the 5-year cycle is ideal to ensure that the ward delimitation is conducted. So 35, there's a feeling that the authority must undertake physical verification before ward changes are made. This is not supported as the bill require already provide for that, and it requires that the board must limit ward in a municipality, taking into account, amongst others, the topography and the physical characteristics. And also, the authority is also not limited to conduct physical verification and site visits to the affected areas, and that is provided for in clause 6H of the bill. And the other matter is general, and is that the authority must have provincial offices and provincial representatives thereof, and which, as I've already alluded in the preceding slides, that that has already been catered for a board to determine its own municipal staff, its own staff establishment, including appointing employees in that approved staff establishment. And the 7th negotiation mandate came from the Western Cape. Other matters were general, the 10-year interval, which we've dealt with earlier, and the lack of presence of provincial authority and the provision for provincial appeals authority as well, and the creation of transitional grant also dealt with in the preceding slides. And the bill proposes on the strengthening of communication and consultation, which I've also dealt with in the preceding slides. So there was a proposal around the definition. There was the feeling that perhaps the definition of the president need to be defined in the bill, which we've accepted, and it is now proposed as the president to mean the head of the state and the head of the national executive as contemplated in section 83A of the Constitution. And the other comment related to composition of board and what has been indicated that whereas the clause provide that the composition of the board must broadly reflect the composition of the South African society and collectively represent a pool of knowledge concerning issues relevant to demarcation, there was a feeling that perhaps that there should be more emphasis placed on gender. And the bill should clearly require that there must be a fair composition of the board members in terms of the gender, which we have indicated that the selection panel should be in a position to consider that as part of the procedure. And as I've indicated, the chairperson of gender equality is also part of the selection panel. And the other matter relate to responsibility of the board to act independently, as this is the similar sort of a comment that came from the from Gauteng province, and we are saying that as it stands now in the bill, the authority or the status of the bill is not really questionable, as it provides that the board must be independent, impartial, and perform its function without fear, favor, or prejudice. So the other comment related to qualification of the board. So the province recommended that in clause 9.2, it should be amended to include persons that hold position in a political party office. And also to amend it as follows. That a person holding a political office or position in a party political office. So this is not supported for the reason that the bill already covers those positions with a political influence. There is a definition that excludes those that are political, are serving in political office, such as your Secretary General and Treasurer, and other positions are provided there in the definition. So in clause 10, it was relating to the composition of selection panel as contemplated in clause 10, which there was a feeling that it might present potential political influence. And there was a recommendation from the province that an alternative selection process for the board may be followed, which could include a parliamentary selection process where nominated persons are interviewed by a multi-party committee of the National Assembly with incorporation of public participation opportunities. And this was noted. However, the composition as provided for now in the bill also go beyond the representation of only the MPs. And in clause 10 as well, there was a concern about the panel having to determine its own procedures. So that is noted, but while the selection panel may determine its own procedure, such procedure must be fair and transparent as contemplated in clause 10.3. Another comment came to appointment of board members as well, and there was a concern that the default position for filling a vacancy on the board requiring the president to fill the vacancy from the additional names that were submitted to the president in terms of subsection 5. And there was a recommendation that any vacancy on the board to be re-advertised and that the process outlined in this section be followed. So it's not supported because the bill as it stands now makes the process for the minister to initiate the relevant appointment process. And if there's none of the additional members that may fill the vacancy, and to avoid delays in restarting the process of recruitment, rather the president had to appoint from the list or that the minister would have provided to the president based on the outcome of the interviews. And on the term of office as well, there was a feeling that members of the board, as they are appointed on a part-time basis as provided for now in the bill, except for the chairperson whose appointment may either be full-time or part-time.
Sorry, Mr. Martin, you are remaining with less than 5 minutes. Thank you.
Okay,
Try and summarize.
Okay. Yeah, so, okay, no, thank you, Chairperson. Yes, that is noted in clause 13.1, provide for appointment of the chairperson by the president and not full-time. This is a matter that the legal drafters may review. And as it relates to the committees, there was a concern around ensuring that there's a limitation on how the committees, the number of the members that the committee, the board may appoint into the committee, which I've dealt with earlier on, that this should be dealt with within the procedures and rules of the board. And in terms of committees, also there was a feeling that the criteria and qualification for the co-opted members should be specified, and that is supported and has been incorporated. And around committees as well, the limitation on the number, it should be up, it should be open, and the province recommended that a provision must be made for limitation in the number of co-opted, which is dealt with in clause 15. And on clause 19 as well, the province indicates that the clause refers to seconded. However, there is no reference to the legal authorization of such secondment. And this is noted, however, the conditions of employment of employees, including secondment, is already covered and is aligned to the principle of PAMA as the DDG has indicated. Factors to be taken into consideration have dealt with similar clause, and we may proceed to the next slide. And the determination of category of municipalities, there was a feeling that there should be an inclusion of more measurable indicators, which is something that may be considered for inclusion in the regulations. Other factors may include the IUDF and the STRs. And in clause 26 as well, it's the 10-year cycle, and I've dealt with much in greater detail in the preceding slides. We can go to the next slide. And the issue around the public consultative meetings for a determination, we've dealt much with those. The bill seeks to maximize community participation in the process. And the intention to omit the word may in exceptional cases, this relates to the temporary allocation of powers and when the boundary takes effect, which the bill indicate that is not supported and that should be retained. And the minister may decide on a different or shorter period only on exceptional cases. On the public participation in delimitation of wards, this has been dealt with in a greater detail in the preceding slide. And the suggestion of the current appeals authorities is inadequate. There was a proposal there. So we're saying that this is a matter for consideration in the regulations. The issue around transitional arrangement measures will also be discussed in detail with the legal drafters and advisors. And this is the last province that provided the negotiating mandate, and Limpopo felt that perhaps in the preceding slide, the requirement for regional diversity relating to the composition of the board in the main act should be retained, and as the DDG has indicated, the changes was effected post the portfolio committee's recommendation. Next. And in clause 10, they felt that the members of national and traditional house, which I dealt with in greater detail, that those are also party to in terms of the redetermination at all levels. Delimitation of ward, the areas of jurisdiction of municipal council must be taken into account. That is dealt with much in greater detail in clause 24, and I've dealt with in the preceding slide. The issue around the appeals authority, they felt that the phrase that says any person should also include persons, because it may not be one person at times, but a group of people submitting an appeal to the authority. So that has been catered for. On my side, Chairperson, that is the end of the part that I was dealing with. I will hand over to the DDG to deal with the specific recommendations. Thank you.
Thank you very much, Mr. Marcher, through you, Chair. So we make this presentation and recommend to the Select Committee for the committee to note the contents of the presentation, the responses that we have provided in relation to the negotiating mandates as received from the 8 provincial legislatures, that the bill has already been translated into 7 languages, isiZulu, Sepedi, isiNdebele, Afrikaans, Sesotho, Setswana, Siswati, and we're also engaging the Office of the Chief State Law Advisor to translate in Tsonga, isiXhosa, and Shivenda. We thank you very much, Honorable Chairperson and honorable members of the committee, for your attention. Thank you.
Thank you very much, Mr. Naidu, DDG, and Mr. Mata, for this informative presentation. Now, let's outline the way of discussing this. We are not going to be opening for submissions to the bill now, but members who are participating here will be allowed to ask for questions, clarities, where things are not clearer, so that will enable provinces to go back to conduct public hearings. Then when the process is brought back to us as a select committee, it's where we'll also deliberate after having received submission from members from provincial legislatures and members of the public. Thereafter, we'll make submissions for approvals to the NCOP. We have now been joined by Deputy Minister Ngamasha, whom we received an apology for him to join the meeting late. The Secretariat have just indicated that we accepted the apology. Now, members, it's your turn to engage the presentation in the manner which I've outlined. Thank you very much. Let's see by show of hands. If your gadget doesn't assist you, you can just indicate and say chair. Then I'll hear and recognize your voice. Then you will have to take the podium. The first member, Honorable Skir Kocher, Honorable Briette, Honorable Brent, Dave Birent, Honorable Bedenhorst, Honorable Peter, Honorable Makesini. Those are the hands that I have on my screen. Let's start in that order, honorable members. Thank you. Remember to open your video and you just talk to the issues as we have highlighted. Thank you.
Thank you, Chairperson. I hope you're well. Mine is, I don't want to extend this meeting because these presentations we've seen before, we've had it before. Mine is just about the public participation. My first question is that I think this was Mr. Naidu just said now, it's only been translated in 7 other languages. My first question is, when will the other remaining languages be translated, because I think that might also have an impact of why certain communities and certain people were not included. Then when do we anticipate this public participation to start and end? Because as I've understand when I spoke to the chair of chairs, Honorable Ryder, from the NCOP side, the notices have already been going out to the provinces. So I would just want to find out that. And then my last question is, how is the department going to ensure, because there was various provinces that indicated, and that is why this is one of the main reasons why the select committees said that this must go back to public participation. What will the department do other than the normal procedures of getting people to come to these public participation meetings? Like, for example, they mentioned the Northern Cape, that's in far areas. How are we going to ensure that? Because usually it's these far-reaching areas that are affected the most through demarcation, and especially when it comes to when it's a voting cycle, then people show up at their voting stations and then they've removed or they're in different ward. So I just want to find out what proactive measures are the department going to do to ensure that and it was also mentioned in the presentation where members of the community want to be involved when this demarcation is happening, and it's not just a submission from politicians that trying to move around so that they can win an award. So just how are we going to make public participation way more efficient, because that is also one of the GNU intents, that we must include the public. Thank you, Chair.
Thank you, Honorable Skirkocher. You have moved out of the GNU. I see you wearing an EFF jacket there. Okay, let's
Since when is EFF grey? I don't know if they've changed their color.
There's a logo of EFF. No, I'm just in a lighter note. It's look like EFF. Thank you. But let's move to the next member, Honorable Priet.
Dankie, voorsitter. Thanks, Chairperson. I'm hoping you can see me and that I am clear. I have a notification that says my internet connection is unstable. So just indicate if I'm unclear and then I will switch off my video. Chairperson?
You're loud and clear. You can proceed.
Perfect. Chairperson, firstly, I would first like a point of clarity, specifically with regards to clause 30 and 31, and then 38 to 46 about public participation and how the board takes its decision. And am I correct in saying that it is the exact same process, except we have an additional remedy where you can go to the court to actually query the decision by the board? And the reason I'm asking this is we've seen that in the Free State specifically, we've had multiple cases of the whole community being against what the Municipal Demarcation Board is actually suggesting, and then they just decide and veto the committee. So I just want clarity on that. Then I would like to have a point of clarity. I see in the presentation made by the department, the Western Cape's procedural comments were left out, and I think that is quite vital to be included as it speaks to the whole process, Chair. And then I maybe also want clarity as to why the department included the negotiating mandates of the previous Parliament in our decision, as our minutes, as we decided in the previous meeting. I think you said it was the 14th of October. And then according to our minutes on the 25th of October, where you obtained legal advice, it was said that provincial legislatures should be given enough time to facilitate public participation in the Independent Municipal Demarcation Authority bill, that the committees unanimously agreed that the bill should be opened up back for public comment in mid-January and complete that towards the end of March 2025. And that, yeah, it just says that we decided not to do that in December. So I would like clarity on to why are we receiving those negotiating mandates? Is the department of the view that we are not going into public participation again and not getting inputs, because that is directly in contravention with what this committee decided, and also what the legal opinion was in that matter, Chairperson. And maybe let me then just park it there. Thank you.
Thank you very much. The Chairperson of Western Cape, Honorable Bryant.
Thank you very much, Chairperson, and thank you for allowing us to be present today. Chairperson, I've just got two queries. The first one is very much in support of this query around the public participation aspect. We certainly haven't seen anything at the Western Cape Parliament yet notifying us of any form of public participation. So my understanding, therefore, is that no public participation has begun. So if we can just provide a little bit more information as to when the public participation process is going to start, because obviously from the Western Cape perspective, we would also be very, very keen to ensure that all of our constituents and residents are included in that process. And then secondly, I believe there was a letter which was sent through to Mr. Masondo, who was the previous chairperson of the NCOP, on the 15th of February last year, which is almost, or just over a year ago, actually, detailing from the Western Cape's perspective, in the name of our speaker, Dalen Mitchell, some concerns that were raised, specifically in terms of the public participation process, and just highlighting that it was felt that the public participation process and the timelines were inadequate, and that would unfortunately delay the provinces and deny them from their constitutional rights to meaningful engagement. I just would like to know whether or not that letter has been received and considered during this process. And then obviously also, as mentioned, just some clarity as to public participation going forward, so that we can start to obviously communicate with the residents of the Western Cape to get that underway. Thank you very much, Chairperson.
Thank you, Chair. Honorable Badenhorst.
Chair, thank you very much. I don't know if I'm on video. My bandwidth is not great in the parliamentary office, but am I audible?
Yes, you are. We can see you as well.
Chair, thank you very much. I'll keep the video on for as long as the bandwidth holds. Chair, I've been covered by Honourable Breed, and I've been covered by Member Brian from the Western Cape Legislature with regards to the omission of the procedural aspect of the negotiating mandate that was sent in by the Western Cape Provincial Legislature last year. It's also important then to note that that letter of the 15th of February speaks to the procedural omission on our negotiating mandate. So the department needs to let us know why. And this is the second presentation in this term, the 7th Parliament, that we're getting on the negotiating mandates. Why that procedural omission keeps on taking place. So secondly, Chair, I think you would recall that you mentioned on the meeting of the 11th of October that we're going to have to get legal advice, and that legal advice wasn't available at that meeting. Regarding what was in that meeting, and your advice was that we would find legal advice on this matter. And I can tell you why legal advice is going to become important on the resumption of this bill, because we are guided by Section 217 of the rules of the National Council which talks to the lapsing and resumption of proceedings on bills in any business before the council. So section 2172 says the proceedings on the bill shall resume at the stage at which that bill was when it lapsed. So this bill lapsed after a flawed public participation process and negotiating mandates were received. And I see that we are now resuming with the same negotiating mandates of that flawed process, which will definitely cause legal issues. And I think that's why it's important that we get legal advice at this stage. So if we are going to refer this bill back to provinces for proper public participation with more than 8 weeks, as this bill demands that in terms of its importance, that we then are we then going to come back with new negotiating mandates instead of the current negotiating mandates that we're sitting with at the moment? I hope that question is clear enough. Thank you very much, Chair.
Thank you. Advocate Mbembe will be the first to respond after we've taken all hands. The next speaker is Honorable Peter.
Thank you, Chair. I don't know whether I'm audible. Can you confirm, Chair?
Yes, you're audible, but we can't see the badge of that jersey, whether it's Springbok or, okay, no, it's Springbok, it's fine, it's acceptable. You can proceed.
Thank you so much, Chair. Some of my question has been covered by Honorable Skirkochen, but I've got only a few questions. Thank you so much for the powerful and informed presentation. That raises these following questions and clarities for purposes. If I'm not mistaken, you will guide me, Chair. My first question is, what informs the board when demarcating the municipal boundaries? So what informs them? Number two, which criteria is the board used when demarcating the ward? My last question is, why is so necessary for the board to demarcate a municipal boundary when the election is around the corner? If just I can be covered on those three questions, I can be pleased. Thank you so much, Chair.
Siyabulela, enkosi Mhlekazi. We'll move to the next member. Honorable Makesini.
Thank you, Chairperson. Let me welcome the presentation. I just want clarity on the issue of the briefing of the Eastern Cape, that when you introduction, that will be done next week, if I'm not mistaken. Is it a continuation of the things that were done on the sixth administration, or is it the process that we have agreed on the last committee meeting? If you can clarify that, so that if it's the continuation or it's a new thing of the briefing, you must give us also the dates of other provinces. Then number two, the issue of the qualification of the members of the board. They say they must have IT. I agree with them. But the issue of the position that they must have in the offices of the employees, is which position are those, or is it a position that is included in clause 27 of the CEO and the other managers? If you can clarify more on that. There's also the issue on the presentation where say the consultation must be done with the MEC, SALGA, and the magistrate and the leadership of the COI and SAD. We request that to be inputted to all the traditional leaders. It must not just be a COI and SAD, it must be inclusive with all the traditional leaders so that we accommodate everyone in the communities. Thank you, Chair.
Thank you, Honorable Makesini. The next member is Honorable Eza, followed by Chief Whip, Honorable Muimang.
No, thank you very much, Chair. I've got an issue with the process of the board to how the board will address the unique challenge of the lack of resources, because I've not heard that maybe when I stood out and went to relieve myself, it just slipped me. Because we know that the board is not decentralized. We know that the decisions taken by the board, as we learned previously on the portfolio committee, that the board sits in a boardroom and actually identifies where it delimitates and demarcates the wards. The issue of access of the board in terms of dispute management to the communities that are affected, particularly in rural areas, as we learned through the public participation. How is the board going to resolve that issue of decentralization of their offices in terms of that? The second issue, I know, Chair, you urged us not to find things to be inserted, but we have 11 official languages. I think I'm asking the question for a very long time now. Has the board, in light of the fact that we have more than 170,000 people that are affected in terms of the provision of the Braille, because at the public hearings, we found that it was not prepared in terms of the document themselves. The Braille benefits about 170,000 people in South Africa, and whether this has been provided in terms of ensuring that when they go to public hearings, this is catered for. The last but not least question is that perhaps we're going to have to speak to the Department of Arts and Culture to look beyond the so-called 11 languages, because we have other languages like Spulane, Spaca, Spond, that should characterize the totality of languages in South Africa, that are, if you like, Chair, they are marginalized, and we put these ones in the public as priority, and therefore, apart from the rural areas being not being engaged in terms of decision making and decentralization, then you have the language issue. We had trouble, Chair. The last one, we had trouble with the issue of public participation in the Western Cape. We almost felt like we were being sabotaged at the time, because when you got to the hall in Kukulet or in Nyanga, there was no one. And with the resources that have been, if you calculate them, political office, people that should come there to educate the public and fetch the public and so forth, all those resources being used of Parliament, and then you don't find the people and you find the venue being thingy. I would like to know from the Western Cape what different public participations will they conduct this time in light of the experiences that have been endured before, whether these delays are a view of the public or community members or politicians themselves, and why, in terms of what we seek to know, Chair. Thank you very much for the opportunity.
Thank you, Honorable Chaza. Honorable Muimang.
Thank you, Honorable Chairperson, Honorable Kaunda. Let me also join the queue in appreciating the presentation Yes, led by Mr. Naidu. 3 questions from my side. The first one relates to the term of clarity on the term of the board. The suggestions that it must be aligned to the term of municipal council. They will just get a sense in terms of the reasoning behind that, given the fact that I suspect the term, if it is aligned with the term of a municipal council, my view is that the issue of long-term planning could be compromised. What are the reasoning behind the move to align the term of the board to a municipal council? The second point relates to I think it's clause 23, which removes the integrated development, the objective of the determination or redetermination of municipal boundaries. Yeah, because I believe that we have, in terms of our broader program of social cohesion, the need to do away with spatial apartheid spatial planning. The issue of integration becomes important, but more than that, the integrated development plan is one of the features of the new developmental local government. Maybe just elaboration behind the reasons for this removal. And then the last one relates to is a process issue. Just building on the point raised by Honorable Bar in terms of our rules. Yeah. You will realize that from the negotiating mandate, there's only one province that necessarily had a challenge, and therefore the select committee as a successor in title, which I believe informed the rules that was referred to by Honorable Baron Hoss, had more impelling reasons as to why the process around the resumption of a lab spell was raised. And I believe that we are a statutory entity. We operate by law, we operate by rules. And if the rules says this is how things must be done, I don't think we have the principles of functus officio, I believe, also takes precedence, which means that necessarily we should be proceeding to where our successor in terms of the committee of the sixth administration ended, and therefore move from negotiating mandate and then once that has been processed by the committee, we then give the legislatures an opportunity to then deliberate on the final mandate. Then the committee takes it from there, because that is what the rule says. And therefore, I just needed to say I suspect, I think the point that is by Honorable Barrow does make sense. Thank you, Chair.
Thank you, honorable members. I've exhausted the hands which was on our screen. Unless if there is someone who couldn't raise the hand who would like to speak, you can indicate by raising your voice. Then we recognize you, then you speak. I don't hear anyone. Let me allow Advocate Mbembe to start outlining the process and responding to some questions, and the department will then join him. Thank you very much.
Thank you, Chairperson, and good morning, members. Chairperson, the Office of the Chairperson did receive the request from Western Cape, among other provinces, regarding the public participation process. And I think the Chairperson noted the concern raised. Hence, Chair, if you remember, a legal advice was provided that the committee should allow a process whereby public participation is afforded, so as not to find ourselves having a constitutional problem. As the court has emphasized in the past, that the provincial processes are intertwined to the NCOP processes. So if there are failures in the provincial public participation, then that will affect the NCOP process in finalizing the bill. So, Chair, we did provide an advice in that regard. Thanks, Chair.
Thank you. Department, you can come in.
Chair, maybe just to follow up before the department.
Yes, Honorable Mima.
Yeah, on the issue of the resumption of a lapse, starting where it lapses.
Advocate, you can come back.
Thanks, Chair. Chair, the Chief Whip is right. Like in terms of the rule, like the process will start where it ended. But in this case, in our advisors, since we have received, if you remember, we have received a number of requests from the provinces. I think Limpopo was one of them, if I'm not mistaken. So the chairperson took that into account and proposed that in order to ensure that we don't have public processes whereby they are being challenged, the provinces should be allowed, and especially those provinces which didn't have a proper public participation, to conduct them in a constitutional manner so that everything can go in terms of the law. Thanks, Chair.
Yeah, if members can recall the legal advice, as advocate have just put it now, we said the provinces which felt that it was inadequate to deal with such matters because of the period in which the public hearings took place. And then the legal advice was that reopen the process, but not nullifying. So it's not mandatory that everything, because even the department, when they responded, there were things which were raised in the provincial mandates, which they had nullified on the basis that some of them are already covered in the bill. So, but this is just becoming a working document so that you emanate processes that the sixth administration have left off, then you start from there. You are not saying it's mandatory to take everything that was said there, but we are opening the process so that provinces can also beef up what was raised and also remove what they feel very strong that it is not supposed to be there, then and bring the fresh mandate to us for processing. I think that's what the legal advice stipulated. Because in government, there's no vacuum. So when there was a sixth administration, you can't say every process that was conducted by the sixth administration is nullified. Or on the basis of what? Because they conducted the process, it was inadequate, not that it was nullified based on the illegalities. So therefore, it necessitates that this becomes a working, that is why the annex charts, when provinces start engaging, they will also be looking at what was proposed and also make their own inputs from there. Thank you very much. I hope I was emphasizing what you have just said, Advocate Mbembe, unless if I'm distorting the message that you are trying to convey.
It's clear, Chairperson, thanks.
Thank you. All right, let's allow Mr. Knight and Mr. Mate to respond, and other departmental officials, and DM if he feels that he wants to make an input on this matter. Thank you.
Thank you very much, Honorable Chairperson. And thank you to the honorable members for the questions, comments that have been made. Perhaps to start by responding to the issue on public participation, Chair, because it has been raised by more than one of the honorable members. And I would suspect that there could be a straddling of responsibilities or perceptions around public participation, because when I look at what Honorable Skier Vogel had raised, so how does the department ensure maximum participation when it comes to public participation? And immediately it came to me that the public participation process that the NCOP needs to lead is an NCOP-led process. Remember, the bill is in Parliament. Parliament is the owner of the bill. And that public participation that each of the provincial legislatures would need to undertake is driven by the provincial legislatures themselves. Now, linked to public participation, there was the issue around how does the board maximize participation. So for me, there were two legs in relation to public participation. The one being the parliamentary process, which I've dealt with. And then it comes to the second leg, which deals with the MDB public participation process. So much of what you see in the provisions in the bill before us, the initiation of the community engagements, the investigating committee that needs to be deployed, the report that must be developed, which must be tabled before the board for consideration, and then a follow-up process in relation to interrogating or placing before the communities affected that report which would have been commissioned by the board. That, for me, is trying to see how the board maximizes public participation in relation to boundary determination, be it for outer boundaries or be it for inner boundaries. And remember, in the presentation that was made, we made the point that presently the provisions in relation to ward delimitation requires in law that the board looks at inner boundary determination. After having done so, it would publish a notice in the Gazette for public consumption for 14 days, whereafter the board would either confirm or vary that ward delimitation that they would have put out for public consumption. The provisions in the bill now requires all of those elements or components that I've mentioned for outer boundary determination must be fulfilled for inner boundary determination. So two very concentrated efforts when it comes to public participation for outer boundaries as well as for inner boundaries. I hope that clarifies the issue around public participation. Chair. I think secondly was the issue of the negotiating mandates and why the department has presented on that. So the invitation for us was clear in that a briefing needs to be made to the select committee on the IMDABL. The presentation was complete and comprehensive in terms of what lives in the IMDABL, but pursuant to that, also that which had been undertaken in the previous administration. Furthermore, you would have noted that the Eastern Cape had not undertaken such a provincial legislature process in that administration. And we had received notice during the week last week that the Eastern Cape legislature was also undertaking such a process, which is scheduled for Thursday this week. So there would appear to be some kind of mismatch that needs to be clarified, because if, as the chair has indicated at the outset, that the process would be commencing towards the end of March in terms of and let me say in inverted commas, introducing the bill to the NCOP, then, the Eastern Cape process seems to be misplaced at this point in time. So those were two broad areas that I thought that I would address in that manner. There were specific issues that were then raised by Honorable Peter. So what informs the board to do outer boundary changes and then inner boundary changes? Perhaps the easier response would be in relation to why does the board undertake inner boundary delimitation? The law is clear in that when wards are delimited, a neighboring ward in a municipality may not deviate by more than 15% of the number of registered voters from one ward to another ward. So in the city of Johannesburg, for example, you have 270 councillors. 50% of that would translate to 135 wards. And if the norm for that municipality is, let's say, 10,000, each of the 135 wards in that municipality may not have less than 8,500 or more than 11,500 wards between each of the wards in that municipality. So it is quite a technical exercise that the board needs to undertake. Various factors to be considered, density, but at the end of the day, in order to comply with the provisions in the law, each ward in a municipality may not deviate by more than 15%. So we provided for that in the legislation or in the bill as it stands, but we've also gone a step further to say that in exceptional circumstances, that the board may deviate by not more than 30%. And let's take the city of Johannesburg again. You have many, let's say, high-rise buildings. You may have hostels. And therefore, in order to not split a hostel into two wards, or an apartment building into two wards, or a settlement into two wards, you may discover that if you go to 30%, you may be able to keep that apartment or that estate in one ward rather than splitting it and getting people from the same estate or settlement going to two different wards to cast a vote. So that is the reason that the board undertakes that inner boundary delimitation. So why are they doing it when elections are around the corner? It is for that very reason that they need to comply with the provisions in the law that the wards did not deviate by more than 15%, because if they do, you're going to be running into trouble with what is there in the structures and in the Demarcation Act. Honorable Treza raises the issue of the provincialization and decentralization of the board. And Honorable Treza, to say that through you, Chair, it has been a matter that the board has been raising with the National Treasury for many a year now. And I would suppose that because of the lack of resources generally in the country, this has not really been something that has actually taken off. But I think, when this engagement would need to be resuscitated with the National Treasury again, to show the advantages or the need for provincialization, decentralization, creating more awareness around the board, we would hope for a better outcome. In relation to the official languages and that which has not been dealt with already, and I think it was a matter that was also raised by Honorable Skierhofer, I think that this is probably the first time we have seen a bill translated, and of course our drive is to get all of the official languages, including Braille. We believe that this is a must in order, because of the importance of the legislation before us. Why it has not been done yet? I think the languages that have not been done yet are probably because the Office of the Chief State Law Advisor would not have that capability in-house already. And if they don't, we would want to see how we explore other ways ensuring that we do translate the bill into all of these official languages, including Honorable Treza, into Braille as well. I think the matter relating to public participation in the Western Cape is a question for the Western Cape Legislature to respond to. The matter raised by Honorable Moimang on the term and clarity behind the reasoning and why alignment to the term of municipal councils. So presently, the way the board's term is structured, or the way it unfolds, is that you would have a board that would conclude outer boundary demarcation. And so, living example, the present board that we have was appointed at the end of 2024.
Sorry, Mr. Naidu, DDG, can you try and summarize? We are still taking another presentation. Thank you.
Thank you very much, Honorable Chair. So in essence, to say that the alignment of the board's term is to ensure that we have one board that oversees or finalizes outer boundary determination, but also to finalize inner boundary delimitation, where presently we have two boards that oversee those two different processes. Honorable Chairperson, I will stop there. Thank you.
Thank you very much, DDG. Honorable Advocate Mbembe, can you just cover the period of 8 weeks? When does it start? When does it end for public hearings? Thank you.
Thanks, Chairperson. Chairperson, based on our advice that we gave to the committee, today is the start of the first week's chair. And then we start counting the first week today and then we are processing. But I'm told, the Chair, that the committee secretariat is unable to determine the exact program, how it will unfold, as it is still waiting for the NCOP to adopt its program on the 20th of this month, Chair. The day after, the committee will be able to develop its own program. Thank you, Chair.
Thank you. This summarizes the engagements that we have engaged on. We agreed that on the 31st of March, the advert for public inputs would be issued, and by the 17th of April, that would be closed. The 8 weeks, a detailed program will be issued to all legislatures to indicate exactly in terms of the dates when does the 8 weeks starts and ends, starting from today's meeting. Then we also wish to advise provinces that when deciding on the public hearings, let's consider a category of issues, including the geographical spread, including the stakeholders who will be directly affected by the bill, but also ensuring that in rural areas, there are hearings that are also taking place in those areas, and not only in bigger cities or in bigger towns, so that we can stretch our own footprint in terms of consultations. So that is very important to all provinces when they decide on how they are going to spread the public hearings. So it's very key that you should not only centralize it to bigger cities, bigger towns, but those people who are living in deep rural areas, they must be afforded with an opportunity to partake in this process. So with that, it closes our discussions. We now move to the second presentation. We'll request the Deputy Minister to lead the team and also delegate the officials to continue presenting to the Select Committee. Your apology was accepted, Honorable Deputy Minister, that you started from the cabinet process before you joined the meeting. Thank you. Over to you, Honorable Namasha.
Honorable Chair, this is Marshal Sedipofa, the Director General at the Department of Traditional Affairs. Deputy Minister Ben Namashe has been in and out because he keeps having to go back into the Cabinet Committee meeting. He did say that he will come out and reconnect a little later, but when I checked the platform, I think he's still held up in the Cabinet Committee meeting. So if the Honorable Chairperson allows, we can start with the presentation with understanding that perhaps time permitting may be able to join us a little bit later.
Yes, it's granted. You may start with the presentation.
Thank you very much once again, Honorable Chair. The presentation we have deals with the statistics on customary initiation in the country. We've looked at all the provinces and we've gone back to 2021, coming to 2024, so that we give the committee a full picture of the statistics. But the presentation also deals, apart from the trends, it deals also with some of the measures that we are busy with. Even now, as we speak, there is work that the Honorable Minister is leading. We just came back from the Eastern Cape, where there was a meeting with the traditional leaders. We are going back to the Eastern Cape this weekend for further engagements with the traditional leaders there, so that we can collectively come out with a solid plan for this year's winter initiation season. We prioritize the Eastern Cape, Honorable Chair and Honorable Members, because as the statistics will show in the presentation, the figures are much higher in the Eastern Cape compared to other provinces. With your permission, Honorable Chair, I will ask our Deputy Director General, Shoki Mohaladi, to take the members through the presentation. Thanks, Chairperson.
Thank you, Honorable Chairperson, honorable members. The DM, if he is back in the meeting, DG, CEO, and all the participants in the meeting. Let me just show my face first. Don't know whether the members are able to see me and whether I'm audible enough, because
yes, we can see you. You are loud and clear.
All right. With your permission, maybe Chair, may I maybe switch off my camera because I have a notification of an unstable network connection. Okay, thanks. As the DG has already introduced the presentation, I won't start with what the presentation is about. Suffice to say that it is as per the brief that you got from the Select Committee, and it provides the breakdown of provincial statistics on initiation. And the purpose of our presentation is for the Select Committee to note the report on statistics of customary initiation deaths from 2021 to 2024. In this slide, we just providing the background in terms of the legislation that the Customary Initiation Act commenced on the 1st of September 2021, and it is the first national legislation to regulate initiation and provide for the norms and standards for the governance of customary initiation schools and all customary initiation practices in the country. And the Act provides for two statutory structures, one at the national level, which is the National Initiation Oversight Committee, as a structure that should oversee initiation nationally, and the establishment of the provincial initiation coordinating committees by the premiers of the relevant province. And these are the legal authorities in all the provinces to monitor and oversee customary initiation at provincial level. So the Act also empowers the department as well as the National Initiation Oversight Committee to monitor compliance with the Act by all the role players. And to do that, the National Initiation Oversight Committee, as well as the department, we convene monitoring sessions prior to each initiation season and post each initiation season. And the monitoring sessions that we have prior to initiation seasons is to monitor the state of readiness for the season, and the ones that we convene post each season are for receiving the report on the season and also to validate the customary initiation reports coming from the provincial initiation coordinating committees. So this particular report, therefore, is as a result of those reports that are signed off by the chairpersons of the 9 PICCs. In this slide, we're just providing a national picture of the deaths of initiates from 2021 to 2024. And as per the graph that we are showing there, in total, we experienced 322 deaths from 2021 to 2024. And of those 322 deaths, 114 were from the winter initiation season and 208 from the summer initiation season. And as members can see, Eastern Cape recorded the highest number of deaths with 60%. And provinces with more than 10 deaths over a 4-year period that come after the Eastern Cape are the Free State with 46 deaths, followed by Mpumalanga with 25 deaths, and by the Northwest with 21, and Gauteng with 14 deaths. KZN usually doesn't have deaths in both seasons. However, this past summer initiation season, it had only 1 death. And then other provinces that have lower death rates, that is less than 11 deaths, are Limpopo and the Western Cape, as indicated in the graph. And I think, and then in this slide, we are just showing that of those 322 deaths, 65%, which is 208, they usually happen in summer, and 35% happen in the winter season. And of the 208 summer initiation deaths, the highest were in the Eastern Cape, which accounts for 65% of those 208 deaths, followed by the Free State and the Northwest with 16 and Western Cape with 9. Other provinces experiencing summer initiation deaths, but at a smaller scale, are usually Gauteng and the Northern Cape. So from this slide, now we are providing the statistics per province. As I indicated, the Eastern Cape has higher death rates, and they are usually in summer, as you can see in the graph there. In summer, the total of the deaths for the Eastern Cape over the 4-year period is 175, of which 58 were recorded in winter and 117 in summer. And of those 175 deaths, 44 were recorded in 2021. And those are the figures for the other years. And the winter deaths are not that high, as I indicated, and the summer deaths in the province are very high. And why we have high rate of deaths in the Eastern Cape in summer is because of some the heat conditions or the weather conditions, which are usually very hot in summer in some of the districts. However, it should be noted that there are certain districts in the Eastern Cape that do not necessarily experience the deaths. In terms of the Free State province, as indicated in the graph there, the total number of initiated deaths over the 4-year period is 46, and 9 were recorded in winter and 37 in summer. And it is for the same reasons as the Eastern Cape, where many of the deaths are in summer due to dehydration and some weather conditions, which leads to medical complications. And then in terms of Gauteng province, the total number of deaths in that province is 14. And unlike in other provinces where summer deaths are higher than the winter deaths, in Gauteng, they are equal number of deaths over the 4-year period. And also there we just indicated that, we just providing that analysis that the province in 2021 recorded 0 death in winter and 1 death in the summer season. And they are generally, the rate of deaths in the province is generally very low. And this may be attributed to the factors or the measures that are put in place by the PICC that are reflected in their reports to ensure that there is high compliance with the Customary Initiation Act in the province, such as the awareness campaigns. They've got training of traditional surgeons, They've got a criteria for registering schools and so on and so on. And then in KZN, as I indicated, there's only one death from 2021 to 2024, and that one death happened during the past summer season. In Limpopo, for the past 4 years, or 2021 to 2024, the province recorded 10 deaths. It's also one of the provinces that has lower death rates, and there were 0 deaths in the province during the summer. As you can see that all the deaths are in winter, and they don't experience any summer deaths, and it may be attributed to the fact that the province doesn't have a summer season in most of its districts, especially for male initiation. And also, as indicated in the graph, you can see that there have been a decline in the deaths from 5 in 2022. 2021, there were no deaths, and this is attributed to the fact also that there was COVID-19 and the province suspended initiation in that year. So in 2022, you'll see it was 5, and it was reduced to, the number of deaths were 5, reduced to 3 in 2023, reduced to 2 in 2024. So there is that declining trend. Also, in the reports of the PICC, you can see that the PICC has measures in place to ensure compliance, but also to ensure that there are no illegal deaths through various interventions that the PICC is implementing. And then in Mpumalanga, the province recorded a total of 25 initiated deaths from 2021 to 2024. And similar to Limpopo, it doesn't experience summer deaths, it's only winter deaths. And there is also a declining trend there, as it is the case with Limpopo. And also the PICC started implementing different measures to pre-initiation seasons to ensure that they don't experience deaths, particularly to eliminate illegal schools as much as possible. And then in the Northwest, the total number of deaths from 2021 to 2024 is 21, and you have 16 in summer, 5 in winter. But the province has also is also trying to reduce the number of deaths over the years, starting from 2022, because that's when and then after they have established their PICC, we started seeing the decline in the number of deaths, because the Northwest PICC was established in August 2023. So you can see that from 2024, in 2024, then the number of deaths started declining. And then in the Northern Cape, this is also one of the provinces that has a very low death rate, and most of their deaths, they happen in summer, and we have got those 4 deaths there. And the lower death rate also suggests that they have effective systems enforcing compliance of the Customary Initiation Act. But what we also see from their reports is that they have awareness campaigns, and they have prioritized also the training of traditional surgeons and principals and other role players. And in terms of the Western Cape, is also one of the provinces that has low death rates generally. It has recorded 9 deaths from 2021 to 2024, and there is also that declining trend there. And this, I think, what is different in the Western Cape in terms of the measures that they've put in place, We have seen that they are able to coordinate all the role players and have buy-in from the role players to work with them during the initiation season. And then in this slide, we're just indicating the causes of deaths and other factors that are contributing to deaths across provinces. The causes there, they include dehydration, all those medical conditions, but some you can just see that is just mere criminality, like where initiates are being shot or they are being beaten up to death, and somewhere is negligence, where is overbleeding. And the other factors that are causing or contributing to the deaths are illegal customary initiation schools. And we are saying that they can be addressed through effective law enforcement mechanisms, which we have already started. We're working with SAPS, and there are many other, I'll talk to that in the next slide. The non-disclosure of medical conditions of initiates or fabrication of medical certificates by parents in most cases, or the initiates or medical practitioners, and that can also be addressed through law enforcement, because we have got Section 33 of the Act, which indicates what should be done in this case. We usually or normally called the offences clause of the Act. Sometimes it's just non-compliance with the Act by the principals, the surgeons, and the caregivers once the school is now registered. And it can also be addressed through intensified training of the principals, the surgeons, the caregivers, the awareness campaigns, and also effective monitoring of the schools. There is also incidences in many cases, especially in the Eastern Cape, of inadequate communities and families' involvement, which also I think can be addressed through joint awareness campaigns by the PICCs, by the National Initiation Oversight Committee, government across the 3 spheres, including municipalities, traditional leadership, and NGOs, and then also inadequate participation of traditional leaders. Though the Act provides that traditional leaders must monitor the initiation schools within their areas of jurisdiction, and also that they must be the ones screening the principals and traditional surgeons and the leaders and compiling a report of those that, according to their screening, should then be registered by the PICC. There are instances in some of the provinces or districts where there is inadequate participation of traditional leaders, and we say this can be addressed through legislative amendments, maybe to strengthen that role, but also awareness campaigns to just sensitize traditional leaders about their role, as well as capacity building of traditional leaders. And then in this slide, these are the interventions to address the casualties. I've already spoken to this, and in the interest of time, I won't be speaking to that. Suffice to say, the legislation that we currently have, it is the good basis for a legal instrument that can be used to address customary initiation casualties. If you look at what the Act provides, though there may be minor or few gaps in the legislation, but it can be complied with, because that has been seen in other provinces. So I won't go through this again, but I will talk to SAPS, what we have done with SAPS at national level, and what SAPS is also doing, because it is important that the South African Police Service is involved, particularly in implementing Section 33 of the Act. We have been requesting SAPS to issue the net joint directives, which have been issued starting from 2024 for both the winter and the summer initiation. They were issuing those directives to the prof joints, and they also issued a list of SAPS officials to all the PICCs. These are the SAPS officials in provinces that should be working with the PICCs in addressing criminality that happens within initiation practices, but also to support the PICCs in the closing of the schools and the monitoring of the schools. And then the DG already spoke to this. I won't talk to this. The ministers' engagements that have started in the Eastern Cape. So in the interest of time, I won't be repeating this, but there are engagements led by the minister. And we believe that the traditional leadership involvement will then be one of the main interventions that may reduce the number of deaths, not only in the province, but in the Eastern Cape, but throughout the country. And we are recommending to the Select Committee to note the report on customary initiation deaths statistics per province from 2021 to 2025. Thank you, Chairperson.
Thank you very much. Let's welcome the presentation. Indeed, it is very disappointing that we still experience such deaths, which can be prevented. But we welcome the presentation and the interventions. Let me allow members to interact with the report. Honourable members, by show of hands, Honourable Badenhorst, you are the first, followed by Honourable Ceza. Honourable Peter, you are the third. Honourable Mabibo, Khosi Mabibo, you are the fourth. Honourable Makesini, you are the fifth. Any other member before we close the list? Because we don't have enough time. Okay, this is where we are closing our list with Honourable Sipati. Okay, let's start. Honourable Badenhorst.
Honourable Chair, thank you very much. I wish I could say thank you for the presentation, but it's a terrible presentation. It's a travesty. It's sad. We're talking about 322 young men between the ages of 16 and 18 that have lost their lives that could have been prevented, like you rightfully said. So my questions would be, number one, are there a regulatory framework in place to regulate this act? Do we have something that basically specifies the practical details, guidelines, how to enforce the act? So are there any regulations in place? And if there are no regulations, why aren't there any? And if there are regulations, why aren't they being enforced? Then the second question is, I mean, I would wonder how many cases of murder or manslaughter or assault have been opened, just say, for example, in the last 5 years with SAPS. And out of that, how many prosecutions were successfully done? Are there accurate records relating to initiation convictions? Is there a report on how many of the illegal initiation operations have been closed down? I think we need to, when we talk about this, and it's preventable, it's young men that are left in the care of older people by their parents. And the duty of care obviously doesn't exist if 322 people lose their lives nationwide. So, yeah, I'd like the department to just address those few questions if they may. Thank you very much.
Thank you. Honourable Ceza.
Thank you very much, Chair. I thought that at the beginning of this presentation, you would ask us for a moment of silence, because every time I'm thinking about presentations that are this nature, which are pertaining to the lives of our people. Moreover, the lives of young men in provinces where customary initiation activities happen. Because when we speak about these statistics, surely we should be having an appreciation of what are the names of those people that have capitulated to this customary initiation practice, so that we pay homage to their families as a humanitarian act of paying support to those who have passed. The second issue, Chair, is that if you look at the trend of this presentation and these statistics, if you look at Gauteng, at one point we met the department on the 15th of November, Chair, 2022, and we had a problem with the issue of gangsterism in Gauteng, for instance. And then there was escalation. There was a number of deaths that were related to that. But if you look now on Gauteng, you will find out the deaths there have dropped due to the functionality of the BICCs in terms of putting measures in place to ensure those illegal activities actually drop. But you can't say the same with the Eastern Cape, because you can say the Eastern Cape, there's lack of governance generally across all sectors. And I think the community then needs to decide what kind of government they need for all these years in the Eastern Cape, where you have issues in the health department, for instance, of scooters. And then you have issues of qualifications and all those things that are illegal in terms of governance. So I think that there should be a point wherein which those PICC are activated in provinces where deaths seem not to drop for both summer and winter season, such as Eastern Cape. Those deaths are one death too much, Chair. I think we agree on that, and measures have to be taken in place to ensure that these do not become like headline news that we are used to, and it's business as usual, that we report on these issues as statistics, and it's business as usual, and there's no consequences that we see that are implemented in terms of the people that are involved in those deaths. Then, Chair, there is and the other issue, Chair, that is very crucial in this thing is the tolerance. Because if we see that there's no consequence management, it seems as though that the Department of Traditional Affairs is tolerant towards ensuring that here are the people that have been found, here are the prosecutions, here are the people in court, because every other cases, we see them on TV, we see that what have they done and so forth.
As you close, Honorable Chaza.
So the risk mitigation strategy and proactiveness in shutting down illegal schools, we can't tolerate, Chair, and excuses for even one life lost due to initiation. And parents have to be exercise utmost vigilance and caution during the initiation season as to where and who and with whom they are taking their children with, and ensuring that they are fully informed on the whereabouts of the children. And so the question that I have, Chair, just one question, is what does the department do in instances where there is non-compliance of the PICC? Who is held liable for the PICC to actually ensure that they comply, Chair? I think that I will leave it there for now. Thank you very much.
Thank you. Honorable Peter.
Thank you, Chair. Thank you so much. Chair, this is a shocking and disgraceful presentation. But thank you for informing us for what transpired in this process of initiations. My question would be, may the department outline the methods of minimizing the deaths in the process of initiations? Number two, does the department feel fit to be part of the customary initiation process due to the high rate of casualties which occurs while this process has been monitored by each department delegates? My last question is, Chair, is the department not the cause of these casualties due to the process of handling the situation so poorly? I thank you, Chair.
Thank you, Honorable Peter. Honorable Mackenzie.
No, thank you, Chairperson. Let me also welcome this report. It's not good at all. I just want to check in Free State, Mpumalanga, and Eastern Cape, which are the regions that are the contributing factors in this death of this initiatives that is happening in this, especially the Eastern Cape and Free State and Mpumalanga, because they are the highest contributors of all the deaths. So if we can get the regions, which region that are contributing more numbers in the Eastern Cape, Free State and Mpumalanga, and whether do we have these structures of PICC that have been active in these three provinces, because the example of the PICC in Gauteng has shown us they work and they give us positive results. Hence, we don't have deaths. But in these three provinces, do we have the structures that they can work with the government and with the community to make sure the loss of our young boys is not happening like it's happening in the Eastern Cape? So if you can tell us, do we have the structures? If no, why we don't have the structures in Free State, Mpumalanga, and in the Eastern Cape? Thank you, Chair.
Thank you. Honorable Sepeti. Honorable Sepati.
Hey. Thank you very much, Chairperson. The presentation was very important, really, because many lives ends when this process of initiations occur. We understand, Chairperson.
Sorry, Honorable Member, can you open your video, please?
Don't use a camera, Zuma.
Party control.
It's next to the mic on your right, Honorable Member, on your right.
I'm trying, Chairperson, but I don't know what's wrong.
I'm a technology.
Aw, Komisa Mandisa.
Now press it once. But you can proceed whilst we are still trying.
Okay,
Chairperson. We don't have time. Thank you.
I'm trying to say, Chairperson, many lives ends when the process of initiations occurs. We understand, Chairperson, that it's cultural because it's the way to adulthood, school through cultural, ritual, and so forth. But when coming to initiations, oh, Chairperson, it's very painful. If maybe the government can speak on the issue of speaking to the stakeholders to comply at all levels and
We've lost you. Can you unmute yourself, honourable member? We've lost you. It seems like you have some technical glitches. Because of limited time that we have on our disposal now, will allow the department to respond to questions raised, and then we closed. Thank you very much. Over to you, departmental officials.
Chairperson.
Oh, sorry, Hosi Mabibo. Sorry. I left you out. Hey.
Okay, my
I can't
leader.
leave Hosi outside of this process. Sorry very much. So sorry for that.
Thank you very much, Chairperson. I think proper consultation should be made to the senior traditional leaders, and the traditional surgeons must be trained in line with the Department of Health. And then COCTA and Contralesa should jointly champion the initiation school. And then bogus initiation schools must or should be reported to the authority. Thank you. That was my submission, sir. Thank you very much.
Thank you, Jose Mabibo, honourable member. That was nice and short, straight to the point on the recommendations. Let's allow the department to respond.
Thank you, Honorable Chair and Honorable members for the questions. Just to confirm that the Honorable Deputy Minister, Ben Demarcation, has since been able to join. But maybe just to indicate in the interest of time that there is information available in a range of areas that the honorable members have raised. For example, Honorable Badenhorst raises the issue of regulations. It's an approach that we have adopted on regulations, which was that as you go into implementation and you engage with stakeholders, understand the areas that would require prioritization on regulations. So one of those areas has been on the potential risk of commercialization of the customer initiation practice. So we've paid particular attention on development of norms and standards around the fees that get charged in customer initiation, the fees that need to be paid. And there's work that is far advanced in this area. And during the course of this new financial year, we'll be going public on that work for purposes of consultation. So that is just an example, and it's something that we can engage with the portfolio, with the select committee some more going forward. I think the issues raised by Honorable Tessa are very critical as well, and I think in terms of the work that we're doing, including the issues around issues of prosecution and consequence management, we will be able to share more statistics on where cases have been opened, what the outcome of those cases has been, although in those presentations will indicate the concern and the trend that some of the cases unfortunately get withdrawn along the way. I think the point that is being made about the outlining the strategies, as has been raised by Honorable Peters. I think because the last slide, 2 slides, has tried to talk in brief around the strategies. The engagement that the Honorable Minister is leading is trying to do exactly that, to make sure that all the stakeholders, relevant stakeholders, are on board. The Honourable Minister and the Deputy Ministers have met with the Kings as the most senior echelon of traditional leadership in the country. They then went a step further to meet with senior traditional leaders, and the level of engagement now goes to further down to headmen and headwomen, and this in an attempt to make sure that all relevant stakeholders are engaged. In fact, I may add that engagements have already taken place, led by the Minister, with the Gender Commission, as well as the CRL Right Commission. But we can be able to engage with the Select Committee going forward in more detail when it comes to those different areas. Similarly, I think the comment made by Honourable Makasini about breakdown per districts, in future engagements we'll be able to share that information, and it will show, for example, in the Eastern Cape, that even in the Eastern Cape itself, you have districts such as Jokabi, where initiation casualties are fairly low, and then you've got districts such as OR Tambo, which is actually leading in terms of initiation casualties. So again, with future engagements, Honourable Chair, will be able to package those as guided by the Select Committee in terms of the information that the committee would require. I would pause there, Honourable Chair. Thank you very much.
Thank you, Honourable DM. You can make your closing statements, your closing remarks on this subject matter, then we close.
Thank you very much, Honourable Chair of the Select Committee, honourable members, colleagues in attendance of this meeting. I think, Honourable Chairperson, on behalf of the Ministry, let me assure members of the Select Committee that we have taken a very bold step in terms of mapping out a plan which seeks to ensure that we achieve zero deaths.
We are losing you, Honourable DM.
And I'm sure all of us,
you can close the video.
Yes. I'm saying all of them, Chair. I'm sure we can see they are all avoidable. They arise as a result of negligence. Now, at the heart of this, more than the role that has to be played by government, we must emphasize the cardinal role of families, because all initiates start and end with families. And in this case, at the level of government, we will do anything and everything possible without the support and active participation of families and communities. Our efforts will not adequately achieve the intended destination. So hence our systematic plan to engage, starting, as Gigi said, starting with the Kings, now meeting with the senior traditional leaders, headmen and headwomen, understanding the dynamics at play at that level. We want to make sure that the whole of society is mobilized, and we will make sure that all of us have our hands on the deck, and regularly we report on the steps that we're taking, including the extent to which we have sharpened the participation of all the sectors of society, especially those who are clearly listed in the legislation. Of course, there's a challenge, Honourable Chair, especially when it comes, remember, it is a function of the justice cluster. However, our engagement with both the police and the National Prosecuting Authority has been structured in such a way that when we start the winter season and the summer season of 2025, we'll make sure that all screws are tightened so that we are able to achieve convictions when there are arrests. So we are determined and very much confident as the department, as the ministers led by Minister Hlabisa on the matter. Thanks very much, Chair.
Thank you, Honorable DM, with those clarities and responses. Firstly, we'd like to express our heartfelt condolences to all the families that have lost their young ones. Two, we are pledging our support when we play our oversight over these matters, over the executive, in terms of remedial measures to stop this scourge. Three, we encourage that the continuity on stakeholder engagement, the special communities, should be elevated in all programs, including constituency offices, to play their role to raise awareness on this matter. We wish to thank you, Deputy Minister and the team from the department, the Demarcation Board, the provincial chairs, and members of legislatures who attended, members of the Select Committee. Thank you for your participation. The meeting stands adjourned. Thank you. We wish you everything of the best for the second term. Thank you very much. The meeting is adjourned.
Chairperson?
Thank you, Chair.
Yes, Moss?
The adoption of the previous minutes, Chair.
Oh, minutes. Oh, okay. Oh, I was rushing to close the meeting. Sorry, let's just, the minutes were issued early. We can just browse through the minutes in terms of confirmation. Can we have a member who have gone through the minutes who participated in that meeting, our last meeting, if these minutes are a true reflection of our deliberations? Can we have a mover?
Before I move, Chair.
Is that Honorable Chaza?
Yes, that's myself, Chair. Before I move,
Yes, Honorable Chaza.
On page 2, deliberations, Chair, if you can go there. A, while generally welcoming the draft, if you see the draft, there should be an E on the draft. And then if you go to B, raised of the select committee, the select committee raised a procedural, not a procedural. Because I tried to look for procedural, I couldn't find it. I found procedural. So those are the two amendments before we adopt it, Chair.
Yeah, you are correct, Honorable Chaza. With those corrections, they will be effected. Are there any further corrections before we adopt the minutes?
Chairperson.
Honorable Makesini?
Thank you, Chair. I just want to check because in the same meeting, we also resolved that we need to have an oversight in provinces. We also determined the municipality. I'm not sure whether I'm correct or not. After the Free State came to the portfolio committee, there were issue of NALA that they must table the report of section 106. I don't see in the program where we are visiting Free State, NALA included, because till today, that report is not tabled to the council. I don't know what must we do, or must we give them a chance, or what is happening. I understand we are visiting section 319 municipality, but we have an issue of NALA, who till today, the report is not yet tabled to the council.
Thank you. There will be a comprehensive report that we are formulating on the visits on the week of the 17th and 18th of March. NALA will be included in those visits. We'll share with members. We are consolidating the list. We'll be visiting a number of municipalities in Free State, excluding Mangaung, because the NA Portfolio Committee have just staged a visit there on the 12th. So we'll share notes with them in terms of what they've discovered on their visits, because we do not want to duplicate the visits that NA was there, then NCOP is also coming in the same municipality. But those matters which were resolved are being processed adequately. All right, let's get a mover for the adoption. Are you also moving, Honorable Matheson?
I move, Chair. With those.
Thank you. Any seconder?
I second, Chair.
Honorable as a second. Thank you very much. The minutes are duly adopted. Thank you, honorable members. Honorable Badenhorst, Honorable Molokome can remain behind, and Honorable Kawunda and Secretariat Shupega will also join us to deal with some of the nitty-gritties. Thank you very much. The meeting is adjourned. Thank you for your attendance. God bless you.
Thank you, Chair.
My colleagues.
Thank you, Chairperson.
Baie dankie, meneer. Baie dankie.
Thank you. We'll request members who have not checked out to check out so that we can resume with our meeting. Lwazi, if you can be able to assist us in removing those who are still remaining and remain with honorable members who are supposed to be here. But I don't see Honorable Badenhorst. It looks like he has checked out. Honorable Molokome has checked out. Let's convene it separately, Bramos.
Okay, noted, Chairperson.
Yeah, members have just checked out. I think they are hungry. It took long. Yeah, let's see in the afternoon, check with them what time can we reconvene. Thank you.